If your claim's governed by ERISA and you're required to file an appeal, you need to be extremely cautious when filing this appeal. I regularly tell my clients that this appeal is going to be even more important than the lawsuit that may need to be filed if the disability insurance company denies the appeal. The reason is because you have to get every single piece of information into this appeal, otherwise the court can never consider the information if you don't win the appeal. So what does that mean? Whatever the insurance company said in the initial denial letter, the appeal is going to be your one and only opportunity to submit a rebuttal to what the disability insurance company said in their denial. Because once you submit your appeal, the insurance company is going to review everything that you submit. And if you don't win that appeal, they are going to submit additional information which we will most likely never have the opportunity to respond to. Now you may be saying, how could that be possible? And unfortunately, that's the way the law is, that once they respond to the appeal, you don't get an opportunity to resubmit anything because the administrative record is closed. So let's just talk briefly in this video about some of the things that can be done in order to perfect your appeal. And we regularly submit appeals on behalf of clients all the time. We've submitted well over 1,000 appeals on behalf of long-term disability claimants. Now, when your appeal is denied, the first step is to take a look at the denial letter and see what did the disability carrier look at? What did they consider? What didn't they consider? And we like to start with, obviously, what's your disabling condition and what can be done in order to prove to the disability insurance company that you are unable to do your occupation or any gainful occupation if that's what the definition is. So when we look at the medical records, we like to see is who's their doctor that reviewed your records? Did they have a doctor? Did they have a nurse look at it? Did they send it out to somebody else? Did they have someone look at you? The likelihood is they didn't even look at you, and they may not have even sent the records out to an outside doctor, so they've only used their internal doctor. So what we like to do is get a hold of all the medical records and a copy of their claim file, which you're entitled to under law. Once they deny you, we request a copy of their claim file. We review the entire claim file. We use our medical physicians and nurses that we regularly work with to review the files and point out any inconsistencies to us. We then take the medical records and the review from the insurance company and send it back to your treating physicians to get them to comment about why they would disagree with the insurance company's treating doctors. That's on the medical aspect. The other things we'll do medically is we'll look at your medical treatment and we'll say, is there anything else that we could do to objectively prove your claim for disability? Because when your doctor's treating you, they're treating you to try to make you feel better. They're not really concerned about how am I going to document your file so that the disability insurance company will continue to pay you. That's what I call medical legal. Your doctor's priority is to make you feel good and treat your condition, not to satisfy the disability insurance company. Unfortunately, when your claim has been denied at this point, you have to shift into the medical legal mode and get your doctor to start to document your medical condition in such a manner that the disability insurance company will be satisfied with the information. So when we look at your file, you usually have 180 days to submit your appeal. We will work with your doctor and our medical team to see what other types of testing or procedures you may be able to go through in order to further prove that you have the restrictions and limitations that prevent you from working. Some other things that we'll regularly do is we will ask you to give us the names of some of your coworkers that you used to work with so that we can get detailed statements from them in order to show the types of difficulties that you were having while doing your work. In addition to speaking with your family and friends about any restrictions and limitations that you have and also speaking with your employer, we will also ask the employer for a copy of your personnel file so that we can see if there's any of your restrictions and limitations which were affecting your ability to do your work. It doesn't always happen that your employer would have written down something that was bothering you, but we want to turn over every stone and get every piece of information that could possibly be favorable for you. So after we get a great understanding of what your occupational duties are, and we coordinate that with your medical restrictions and limitations, we will then very often consult with a vocational rehabilitation expert and say, look, here are the medical restrictions and limitations. Here is what the person's job duties were, and here's what their educational background and experience was. Is there any job in the marketplace that you think this person can do based upon their disabling condition? Now, very often in a lot of disability cases, when you get to the denial, it's usually in the any occupation stage. But the any occupation stage will usually say, unable to perform any occupation in which you can only earn 60% of what you used to earn. So there's this income threshold. And because of that income threshold, if you used to earn $100,000 and now 60% of that would be $60,000, the disability carrier has to say, taking into consideration your restrictions and limitations, we think that you could do this job in the marketplace that would pay $60,000. So we go out to an expert who does a labor market analysis as well as a vocational rehabilitation analysis and says, these are the jobs that are realistically available in the market. These are the skills that are required to do this job, and I think that this person can or cannot do this job. And based upon the results we get from that report, we use that as additional support for your appeal. Now, once we submit this appeal, the disability carrier has 45 days initially to make a decision. Then they can ask for 245 days extension, and hopefully at that point, if your appeal's won, they have to reinstate your benefits and continue to pay you on a monthly basis. And if you don't win your appeal, your next option is to file a lawsuit at that point in time. But it's not until the appeal's over that you can file a lawsuit. And I always say to my clients, look, if that appeal is submitted and then they make their final decision, and then the next day, God forbid, you were to get run over by a truck or have a really bad injury, you are not allowed to submit that information back to the insurance company. Well, you can submit it to the insurance company, but the court will not be allowed to consider that. So every single thing has to be thought of beforehand and in the ERISA appeal. You have to win your case before you even get to trial. And that's why you really need to speak with an attorney and someone who's experienced in handling these ERISA appeals.